the counterpart electoral processes, full-fledged legal and regulatory framework, and it cannot fall from the mouth of IBC that a like framework for signature verification for a popular initiative is a superfluity, because I think it is not. Given that state of things, I am convinced that the conclusions reached that IBC lacked the requisite legal and regulatory framework in the specific issues of signature verification, and that the stopgap administrative procedures were invalid, were unassailable, and I would not interfere with them. On IBC quorum, I think a lot has been said. I am in total agreement with my brother, Justice Gatembu, when he came to the conclusion that the quorum of IBC cannot be 3. The quorum of IBC must be 5. To my mind, such a vital role done by IBC requires the full complement of IBC with all hands on deck. It is, to me, another instance of officials' failure on the IBC, which, while fully aware of its current limping status, its commissioners having dropped to below half of what the Act prescribes, for it to wear a brave face and state in legal proceedings no less that it's doing just fine. A more honorable stance would have been for the IBC and the Attorney General to make a clean breast of it and consider the former needed urgent help and send an SOS to the appointing authority to bring that intolerable state of affairs to an end by making the necessary appointments to empower IBC for the performance of its key mandates, including the conduct of referenda as stated in Article 884 of the Constitution and required in Article 257. Its relevant statute demands immediate filling of the positions of commissioner that fall vacant. It is fortuitous that interviews have since been conducted, and IBC should shortly be fully constituted and not a day too soon. I think I can leave that particular one and move on to, I would therefore agree with and affirm the landed judge's holding that all the decisions made by IBC in relation to the proposed constitutional amendments via the BBI Amendment Bill were invalid, null and void for lack of quorum. On voter registration, again, I've said quite a bit, and the evidence seems to be that IBC had managed to register some 108,000 more voters up to the time of the Kibra election of 2018. During argument of the appeal, it came out quite clearly that there really has not been any serious and sustained continuous voter registration. It is also clear that the numbers indicated are measly, to say the least, when thousands of young people are daily attaining the age of majority. And I would say, and not accept the argument made before us that it was upon the petitioner to prove the contrary. He bore no burden, because it is the IBC that keeps the records, and it is it that had the duty to show that there was continuous voter registration. It would have been an unacceptable dereliction of duty and violation of rights were the referendum to be held with hundreds of thousands or millions even of young people sitting it out on account of not being registered. Where the referendum in question involves proposed changes to the Constitution, it is this very segment of the citizenry, the very youngest of adults, who have the greatest stake in the matter, and everything should be done to aid in having their voice heard, their vote taken, and their decision made known. Indeed, it's further testimony of the nonchalance that attends the question that the registration of young people as voters is a matter that has to be pursued as a chore, when attainment of majority ought to lead to an automatic registration as a voter. I know that the report by the Kriegler Commission dated 17th September 2008 on this very aspect has never been actioned more than a decade later. They had indicated that it should be very easy. The moment someone gets an ID, they should also be registered as a voter, but that seems not to have been done until now. The format of the referendum question, I would say with respect, again, I agree that lumping all those questions together brings a problem. But first of all, the argument was made that the judges should not have told the IBC how to go about it, because that is trying to control them. But I suggest that I do not understand independence of commissions to mean that they are any way beyond being told by the courts what the law is. Now, if I may pause here for a moment, it becomes clear that some amendments to the Constitution do not require the involvement of the people generally at a referendum. And one of the problems of the IBC bill is that it contains both matters that require a referendum and others that do not. It contains multiple and altogether way too many proposed amendments, some of which would require a referendum while others do not. The confusion becomes intolerable in that a bill is prepared containing provisions that from their different proposed impacts requires two different tracks for enactment. Indeed, because of the numerosity of the questions, I think I have said that I do not for a moment think that it was ever the intention of the people that amendments to the Constitution should be the normal done thing whenever we feel the urge. It should come rarely, and even then when compelled by the greatest necessity. And for that reason, an amendment should come singly, once, rarely. If for any reason, and I cannot readily conceive of any, amendments must be brought other than singly, the original intent must be maintained by having each amendment presented separately and distinctly to be voted upon independently. That way, the choice presented to the people is not a binary one, and the people do not have to feel ramroded into choosing what they do not like alongside what they like, or vice versa. That Hobson's choice may perhaps be avoided by way of a multi-option referendum, but I will refrain from making any conclusive findings on it in the absence of a referendum act, the desirability of which I have already addressed under the rubric of legal and regulatory framework. I have taken the view that whereas Section 49 of the Elections Act does envision multi-question referendum, I would think, however, that whereas the section applies to referendums generally, the specific proposed constitutional amendment under People's Initiative in Article 257 must be presented as a single amendment at a referendum for the people to either approve or reject. On the whole, therefore, I do find and hold that the learned judges were right in holding that specific proposed amendments must be submitted as separate and distinct referendum questions. I would only preface the relevant part of the declaration by the words must be presented singly, or I would in any event reject the grounds of appeal preferred against the holdings on the structure or format of the referendum question. I've taken the view that having too many of them in one question amounts to an interrogatory overload. On the question of constituency, apportionment, and delimitation, I note that IBC, which to its credit has not appealed against the findings of the learned judges on the aspect of the case, is required under the BBI bill to determine the boundaries of the 70 extra constituencies within 6 months of the commencement of the Act in the counties among which the new constituencies are spread in the manner specified. The learned judges undertook a detailed historical account of constituency delimitations, which goes to show how the matter is a delicate, emotive, and often highly contentious exercise, and guarded by what Kriegler report termed the gross disparities in the voting populations and gross disparity in the size of Kenya's constituencies. In a report by the IBRC, it identified historical injustices and past gerrymandering as having highly contributed to the 2007 post-election debacle. Now, I have generally agreed with the learned judges, and I hold without hesitation in rejecting the complaint that the learned judges erred in not exercising judicial restraint or constitutional avoidance, that I am in full agreement with this court reasoning and holding aforesaid, and that is in the case of Coalition for Democracy, CORD versus the Republic. It resonates with what I stated earlier when treating of the basic structure doctrine that the Constitution places on judges an unmistakable obligation to defend the Constitution where there is real, clear, and present danger of violation or contravention of rights or an unlawful tinkering with or alteration of the Constitution's basic structure, such as portended by some of the provisions of the BBI Amendment Bill. The courts, when moved, must take defensive action in aid of the Constitution, even by making a preemptive strike that ensures the threatened constitutional amendments do not see the light of day. I have again referred to Mr. Karori's arguments in which he talks about the difference between the power of IBC over wards and over constituencies, which I agree with, but a careful reading of the judgment does not suggest to me that the learned judges held that the number of constituencies cannot be altered. I think they stated the opposite, and quite emphatically and unambiguously so, which again I have quoted them. What the learned judges did hold was that it was impermissible for the BBI Amendment Bill to directly allocate and apportion the 70 extra constituencies it created without the delimitation exercise that is commanded and provided for in detail to be undertaken by IBC in Article 89, which lists and Article 88.4, which lists the delimitation of constituencies and wards as one of the particular, and I dare say, exclusive responsibilities of IBC. To my mind, the protective role of independence commissions over the sovereignty of the people is of critical, over the delegation of the sovereignty of the people is critical and vital importance, and can only be attained by a jealous and uncompromising assertion, exercise, and defense of their independence. Independent commissions are charged with the duty of vigilantly and keenly ensuring that the state organs to which sovereign power is delegated maintain the stance of delegates accountable to their principles and remain always the servants of the people. And therein lies the absolute necessity of the independence of those commissions being kept firm and inviolate. I would thus hold that seeing how critical the independence of independence commissions is to the sovereignty of the people, it has to be part of the basic structure of the Constitution, which is given express amplitude by entrenchment. Having taken this view, it should be obvious that I find the provisions of the BBI Amendment Bill to be an unconstitutional attack on the independence of the IBC, and materially seek to alter by the operation of various of its provisions the limitation scheme set out in Article 89.1 of the Constitution. It effectively attempts to repeal that provision without saying so by stealth and subterfuge. Now, it is a statement to the thoroughness of forensic analysis and intellectual engagement the learned judges brought into this aspect of the case, as indeed the entire case, that they proceeded to expound in some detail on each of the 6 reasons or markers of unconstitutionality that they identified in the BBI bill. I'm not to go into them. As I am myself fully satisfied with the accuracy and logical legal foundations of those reasons, I do not consider necessary to rehash them. The conclusion is inescapable that being so violative of the Constitution, the provisions of the BBI Amendment Bill were benighted and ill-fated at inception and had to be struck down as null and void. As to the cross appeals, I am in full agreement that both of them should fail, and that's my position. And so, finally, in conclusion, I would express my deep gratitude to all counsel and parties who appeared before us. The depth and extent of learning that went into the preparation of these appeals and cross appeals by both sides of the divide was truly impressive. The authorities were numerous and the workload quite daunting, and I must commend the industry and commitment on display before us. The erudite submissions made passionately and with persuasive force exemplify the importance of oral advocacy at the bar by both seasoned seniors and talented young legal eagles. The latter exemplify Chinua Achebe's quip in Things Fall Apart that when a child washes his hands, he gets to eat with kings. These young lawyers will soar to great heights, and should they maintain the discipline, hard work, courtesy, and professionalism that was in prodigious display before us. There is reason for optimism that the future of the profession is safe despite present troubles. As the cases, textbooks, articles, commentaries, and other authorities were in their scores, running into hundreds, nay, thousands of pages, it was not possible to refer to each and every one of them, just as it was not practical to quote verbatim all the submissions made before us for days, not to mention the hundreds of pages of the same in writing. My not having referred to any of them is no indication of their lack or worth of work or importance, but merely the function of limited space and time. In the end, I trust that we have all kept the Constitution safe and secure on this occasion, and may it always remain so. Thank you.
Well, thank you, my brother Justice Kiage. It is now about 10 minutes to 5, so we'll take 10 minutes health break, then come and finalize the remaining judgments.